So let's start Transfer of Property Act. Let's do it in one shot. Um, yes, so there are 8 chapters. Preliminary chapter is from 1 to 4. Transfer of property by act of parties 5 to 53A. Sale 54 to 57. Mortgage 58 to 104. Lease 105 to 107. Exchange 118 to 121. Gift 122 to 129. And transfer of actionable claim, that is 132 to 136. Okay, so basically transfer of property act deals with transfer of a property, and transfer is that of either the right or interest, and property means both movable and immovable, whereas transfer of property deals with only immovable properties transfer. Movable property can be transferred under Transfer of Property Act, and then majority of the provisions are dealt under the Sales of Goods Act. Okay, so Sales of Goods Act, majority of it is dealt under, and some of it is under the Transfer of Property Act. So Transfer of Property Act and Sales of Goods Act, both it is dealt with, but immovable property only Transfer of Property Act is concerned with. Okay, now it is a codified law. It is substantive in nature because it is defining the rights and liabilities, so it is substantive in nature. Whether it is exhaustive, no, it is not exhaustive, because Indian Contract Act, CPC, Specific Relief Act, and Indian Registration Act completed. So all of these together will be exhaustive. Transfer of property just defines a part, or it defines or regulates only certain kinds of uh, transfers, and that too not in comprehensive manner, because you have to go to Registration Act sometimes, you have to go to Specific Relief Act sometimes, so that's why it is not exhaustive. Okay, now before Transfer of Property Act, what was governing the this transfer of property? It was equity, justice, and good conscience. Equity, justice, and good conscience, it was governed by. Okay, now Transfer of Property Act, it is came into force in 1882. It is Act number 4 of 1882, and it has 8 chapters, 137 sections. Came into force on 1st July 1882. Then again, it is under the third list, entry 6, schedule 7. So if it is in the third list, then it is concurrent or union, or what list it is? Tell me. If it is in the third list, yes. So it is concurrent. So that means both state plus central both can make rules. Okay, and yes, it applies to both movable and immovable property. Okay, now you have to understand that transfer is when you are basically transferring an interest or a right over a property, and that can be done in two ways. Either it can be done by act of parties, or it can be done by operation of law. Okay, act of parties, when parties decide and they transfer it. Operation of law is after their death, law takes into effect and transfer it. Operation of law is both, it is either succession or execution. That is what it is done. Act of parties, of course, a will can be done. That is also an act of parties, but that is governed under Indian Succession Act. But if it is act of parties while the parties are living, because will takes into effect after parties die, but um, while the parties are living, if we want to transfer a property, then that can be done through Transfer of Property Act, and that is given herewith. Sale 54 to 57, mortgage 58 to 104, lease 105 to 117, exchange 118 to 121, gift 122 to 129, and actionable claim is 130 to 137. Okay, this is our what inter-virus transfer, that is transfer between living person. We are concerned with this. Okay, now yes, section 1 says it applies to the whole of India. To which part it does not apply? It says Bombay, Delhi, and Punjab. and that is, or some part B states, it says it does not apply. While it came into force, it was not applying. But of course, the state government has the power to apply to any part. So obviously, right now it has already been applied over these states. Okay. Now, except all these sections, everything else can be applied by the state in these territories that has been given. Okay. Now, coming to section 2. Section 2 is talking about repeal. You may just look to it, it's not that important. Coming to section 3. Section 3 is says that what is an immovable property. Crucial definition, it says that uh, TPA just says that it does not include standing timber, growing crop and grass. It says that it does not include standing timber, growing crop and grass, but the complete definition is not given. To see the complete definition, we have to see section 3 clause 26 of the General Clauses Act, in which it is given that it is either land, benefits arising out of land, and things attached to the earth. Land, benefit arising out of land, and things attached to the earth. And things attached to earth includes again three things, that is rooted, embedded, and attached to something so embedded. Okay, so these three things are included under things attached to the earth, and all of these land, benefits arising out of land, and things attached to the earth are coming under immovable property. If you look into transfer of property, it does not define it, it just says these are not included under the definition of immovable property. Okay, now again, what do you understand by attested? Attested means it is attested by two or more witnesses. Now, each of these such witnesses must have seen the executant sign or affix his mark and sign in executant's presence or direction. Okay, or received personal acknowledgement from the executant regarding the signature, then only it will be an attestation. Do ଦୁଇଟାରୁ ଅଧିକ ଲୋକ ଯଦି ଦେଖିଥିବେ executant who sign କରିବାରେ, or must have seen uh, or must and sign in the presence of sign in presence of the sign in the presence of or the direct under the direction of the executant, or received personal acknowledgement from the executant that there is signature, then it can be deemed as a valid attestation. Okay. Next, some more thing is actionable claim that we will discuss while deciding the discussing the last chapter, that is actionable claim. Okay, instrument means non-testamentary instrument. Okay, instrument means non-testamentary instrument, only non-testamentary instrument. Testamentary instrument we are not concerned with. Okay, and registered means registered under any law, that will be called registration. Now another important definition is notice. Notice is registered in any law. Then coming to notice, notice is can be of two types: actual notice and constructive notice. Actual notice is when person actually knows. Okay, and constructive notice is when that thing he would have known if he had not willfully abstained, or he would not have been negligent, then definitely you would have known. ଆପଣଙ୍କ ପାଖରେ ଗୋଟେ ପୋଷ୍ଟ ଆସିଲା, ଆପଣ ତାକୁ ନ ପଢ଼ିକି ଫେରେଇ ଦେଉଛନ୍ତି, then it will be deemed you have a constructive notice. Okay, now explanation 1 କହିଲା registration ଯଦି ହେଲା, that's also a notice. Possession sometimes is a notice, and notice to agent is also a notice to the principal, except when it has been done through fraud or concealment. Except when it has been done through fraud or concealment. Okay, now coming to section 4. Section 4 koila transfer of property act is not complete. It is while it relates to the contract, part of Indian contract it is applicable, and also certain sections are supplementary to Indian Registration Act, and that only completes it. So without ICA and IRA, you will not be able to read transfer of property as a whole. Okay. Now, transfer of property by act of parties. Transfer of property by act of parties is given in section uh, 5. Section 5 says that living person, when one living person conveys in present or in future to another living person, either himself or another living person, then in that case it will be called transfer of property. Such living person can be company, association, or body of individuals also, no issues, but still it would be called a transfer. Okay. Now section 6 says what may be transferred. It says any kind of property may be transferred. There is no issue, absolutely you can transfer any kind of property, but you'll have to check there are certain kinds of property which cannot be transferred. So if these are certain properties which cannot be transferred, barring that all properties can be transferred. So what cannot be transferred? It says chance of heir apparent, that is space succession. Space succession is I have a mere chance of succession, then I can't transfer it. Okay, I say that yes, suppose X says that after X father dies, so X says that after my father dies, I will get this property from him. So I want to transfer this property now. Can he do the same? No, because it is just a chance of succession. He might succeed or he might not succeed. So you cannot say that I will transfer it. Okay. Now chance of, because there is a chance that he might will in favor of someone else. Okay. Next, chance of legacy. Chance of legacy also another further remote chance, when you say somebody might will it in my favor and then I want to transfer it. That also cannot be done, because if this obvious chance is not being allowed, then of course this remote chance will not be allowed as well. Also possibility of like nature, all these cannot be transferred. Now mere right of re-entry. What is mere right of re-entry? Mere right of re-entry, it says, suppose A says that I am transferring this property to B, but if he does something, transferring as in suppose lease, not absolute transfer. Of course, on absolute transfer conditions cannot be put, but he transfers a property on lease and says that if B does something detrimental to the interest of the property, then I will have a right to re-entry, or I will have a right to get it back. Now, whether he can transfer that right of re-entry, no, primary right of re-entry cannot be transferred. Of course, if he transfers that property, then along with it, the right of re-entry also goes. Similarly, easementary right also cannot be transferred apart from the dominant heritage. Now, what is dominant heritage and what is servient heritage? Yes, this is a property, okay, and this is another property B. Now, what happens that the public road is here, so to access this public road, A has to pass through the land of B. Okay, so this particular land B is serving this land A, hence this land which is taking this service of accessing the road is known as dominant heritage, while the land which is serving it is known as servient heritage. So, if you want to, so if can I just transfer this right of way, that is this easement that I have, can I just simply transfer this? No. If I have to transfer it, I will have to transfer the dominant heritage itself. Okay, along with the dominant heritage, I may be able to transfer, but other than that, there is no way I can transfer it apart from the dominant heritage. Okay, next, restricted rights cannot be transferred as well. Similarly, rights of future maintenance, if I have a right to future maintenance, that rights cannot be transferred as well. Mere right to sue, I have a mere right to sue, but I want to transfer that right so that somebody else may sue. No, that cannot be transferred as well. Now, public officer's salary of a public officer cannot be transferred as well. Stipend of military, naval, or air force, those cannot be transferred as well. Of course, these are for the public interest. That, of course, if these are allowed to be transferred, then public policy would be affected. Now, any property opposed to the nature of business affected thereby. So that means if I want to say I want to transfer an ox, ox belongs to no one. Ox is a rational, yes, so that cannot be transferred. I would say suppose res communis, res communis. Whether I can transfer? No, I cannot transfer. I cannot transfer if I have to think that uh, um, uh, like air. Can I transfer? No, I cannot transfer. Now res extra commercia or also like things outside business commerce. I will say I will transfer moon. No, can I transfer moon? No, I cannot transfer moon. Okay. Similarly, a property for unlawful consideration of the object that also cannot be transferred. That's what section 2324 Indian Contract Act says. So a property for unlawful consideration or object cannot be transferred as well. Similarly, a person if he is legally disqualified to be a transferee, then also a property cannot be transferred in favor of him under section 136. Okay, so these are the properties which cannot be transferred. Other than that, any property can be transferred. Other than that, any property can be transferred. Okay, next, who can transfer? Section 7 says who can transfer. Okay, any person who is competent to contract, that is major, sound mind, and not disqualified by law, and he is entitled to transfer property, that is uh, that means he has either the property or authorized to dispose. He's competent to contract. He's either entitled or authorized to dispose. That means it is not his property, but he has a power of attorney. Then also he is authorized to dispose. So either he is entitled to transfer or authorized to dispose. In both cases, he can transfer it. Okay. Now, so yes, transfer he can do it either wholly or partially. He can also do it absolutely or conditionally. If he wants, he can also transfer it absolutely or conditionally. Okay. Now, coming to the next section, that is operation of transfer. Operation of transfer says if you transfer a land, then along with that, easement, rent, profits also go. If you transfer machinery, movable parts thereof also go. If you transfer a house, then door, window, keys also go. If you transfer accounts, then securities also go. If you transfer money, then income, interest also go. Okay, so illegal incidents or attached thing will also be transferred with the main property. That is what section 8 says. And section 9 is oral transfer. That means it can be transferred without writing as well. Just by oral transfer also transfer can be done. Now section 10, 11, 12 gives out certain conditions. If they are put in a transfer, then those conditions will be void, but the transfer will be valid. What are those conditions? It says first, condition restraining alienation. Okay, so there is an absolute transfer. You are putting a condition which is restraining the alienation, that you are saying that you can't transfer it anymore. I am absolutely transferring it to you. Now I am saying that you can't transfer it to anyone. That whether that condition can be put, no, that condition will be void, but the transfer will be valid. Similarly, if I say that yes, I am transferring this property to you, but you can't enjoy it at all in this manner. You cannot enjoy it in this manner. Whether I can put a condition like that? No, I cannot put a condition like that. And if I put a condition like that, that condition will be that condition will be void. That condition will be void, and the transfer will be valid. Similarly, section 12 says if I put a condition that the transfer will cease if the transferee is insolvent or attempted alienation. If he is declared insolvent, or if he attempts to alienate, that is transfer, then in that case the transfer will come to cease. Transfer will not be there anymore. In that case also, that condition is void. that condition is void and the transfer is valid. Okay, so I can't put these conditions under section 10, 11, 12. If I put a condition while transferring these then such conditions will be void and transfer will be valid. Okay, so transfer can be of absolute, partial, but in absolute, whether I can put any condition? No. In partial condition I can put or not? Yes, partial condition I can put, but absolute condition if I put, then that case that will in fact debar me from putting any condition. Now coming to section 13. Section 13 talks about transfer for benefit of unborn person. What does it say? That in a transfer of property, you are creating an interest for the benefit of a person who is not in existence at the date of transfer. That means he is an unborn person. Now, you are creating a prior interest by the same transfer, and the interest is ultimately created in favor of benefit of the one person, but of course you are creating a prior interest. Then it says it shall not take effect unless it extends to the whole of the remaining interest of the transferor in the property. Okay, let's understand this. What does it say? So that if I say that if I have to transfer, if A wants to transfer it to his unborn suppose what unborn son, or unborn A wants to transfer it to his unborn son. So he says, I am transferring to B for life and then to C, his unborn son. Yes, it can be done, but of course, this transfer in favor of this unborn person must be absolute. That means the remaining of the whole of the interest must be given to the unborn person. Okay, and unborn person must come into existence before the death of the life interest holder. Before B expires, C must come into existence, otherwise this transfer will be invalid. Of course, I can create many life interest holders. I can create D, I can create E, I can keep it like that, but at least C must come into effect, or C must come into the picture before their death, before the death of the life interest holders. Otherwise, it will not be a valid transfer. Okay, so section 13 says this much. Now section 14 in fact supplements it and says that yes, you can transfer for the benefit of one person, but the property cannot be held in perpetuity, and maximum time the property can be held in abeyance is after the lifetime of one or more persons living at the date of transfer, and the minority of some person who shall be in existence at the expiration of that years, and to whom if he attains full age the interest created is to belong. Okay, so what does it mean? So I can say that yeah, I am transferring to B for life, then B son for life, then B son for life, then B son for life, but ultimately it must be given to if it is given to C, then on C attaining 18 years. Okay, so maximum it can be the maximum it can be held in abeyance is lifetime of the life interest holders plus interest holders plus the 18 years. One more thing would be super added is the gestation period. That is, if he is kept in womb, the period that the one person is in womb, that period also can be included. So maximum, this is the time limit during which the rule against perpetuity applies. That means you can hold this property in abeyance for this particular time, not beyond that. Okay, so vesting can be maximum for the time postponed to the prior life interest holders time plus minority of the unborn person, that is 18 years, and as I told you, another thing can be added is gestation period. Okay, not beyond that. Okay, now but section 20 says just because it is transferred to unborn person does not mean that he does not have a vested interest. Upon his birth, he will have a vested interest, even though the enjoyment is postponed. Still, then, upon his birth, he gets a vested interest. That's what it says. Now, Section 18 says that yes, if you are transferring it for the advancement of religion, knowledge, health, safety of mankind, then in that case, transfer in perpetuity is also allowed. Okay, normally in Section 18 it was not allowed, Section 14, but in Section 18 for the advancement of religion, knowledge, health, safety of mankind, etc., then in that case, transfer in perpetuity can be allowed. Okay. Now, Section 15 says transfer to a class, some of whom come under Section 13 and 14. It says that suppose A is transferring to two persons. Okay, two persons, that is unborn person 1 and unborn person 2. He has created some prior interest holders, but he says unborn person 1 will get it on him attaining 18 years, but unborn person 2 will get it on him becoming 22 years. But we have studied in Section 14 that it can be maximum postponed up to 18 years of the life of the unborn person. So that means the second transfer, that is on him becoming 22 years, is void. That's why only in respect of UB1, that is unborn person 1, it will be valid. Okay. Then coming to Section 16. If there is a transfer and I say that it will take effect on the failure of the prior interest, then in that case, if the prior interest fails, then the transfer in favor of the unborn person also fails. So I am transferring it to prior interest holder 1 and 2, but I am saying that uh, prior interest holder here is not born, then of course it cannot be done, it cannot be postponed. Then in such a case, whether you can transfer it to unborn person, no, the transfer in favor of the unborn person will also fail. That is what it says, the transfer in favor of the unborn person will also fail. Okay. Now coming to the section 17. Section 17 says direction of accumulation, which is an again exception to section 11, which says what is accumulation. Accumulation is collection of income of property or rent or profit. So it says that income arising out of the property shall be accumulated during a period of lifetime of the transferor or a period of 18 years. So normally section 11 says you could not restrain it to be enjoyed in a particular manner, but if this is the case that you are accumulating for a period for the lifetime of the transferor or for a period of 18 years, such accumulations direction is valid and it can be done, no issues. Okay. So this is for the maximum period it can be transferred, and direction making accumulation after this period will be void. If you make a direction for accumulation after this period, that will be void, but that does not mean that you can't direct for an accumulation. Okay, but yes, up to maximum this period you can direct for an accumulation. Okay. So this is it, and that yes, you can direct for an accumulation, but maximum is for the lifetime of the transferor or the period of 18 years, lifetime of the transferor or a period of 18 years. Okay. Next, what else does it say? Just a second. Yes. So maximum period for which that direction for accumulation can be done is lifetime of the lifetime of the transferor, or for a period of 18 years, whichever is longer. Beyond that, if there is any accumulation, that can be void. Okay. But of course, again, we studied that for the advancement of benefit, advancement of religion, etc., the direction can be for longer as well. That is, yes, it is said that if it is for the payment of debt of the transferor, or for raising a portion of children, or for maintenance of the property, then in that case you can use it as an exception, and beyond the said period also you can direct for an accumulation to be made. Now coming to section 19, what does it say about vested interest? Vested interest, I say that yes, I am creating an interest, but I am not specifying when it is to take effect. Okay, or by specifying that it is to take effect forthwith or on happening of event which must happen. Okay, if I say that I will transfer this property when on the death of A, on the death of A, so that means here that event is certain. That event is certain, or I am not saying any when it is to take effect. I am saying just right now I'm transferring this. So I'm not mentioning any time when it is to take effect. So in these cases, what happens that it is depending upon a certain event. Okay, in such a case, the interest is deemed to be vested. And once it is vested, it is not defeated by the death of the transferee. Even if he dies before taking the possession, still then it would not be defeated. Okay. Now, yes, just because the enjoyment is postponed does not mean that the interest will be affected. Next, income arising from the property is directed to be accumulated under section 17 does not mean that interest is not vested. Yes, right of enjoyment might be postponed, but still the interest can be deemed to be vested. Same if there is a prior interest created under section 13, then right of enjoyment of unborn person may be postponed. That does not mean that the interest ceases to be vested. It will still be vested. Okay. So section 19 says this much. Now coming to contingent interest. Contingent interest is upon uncertain event. Uncertain event. Now what does it say? That I am creating an interest, but I am saying that it will happen on the specified uncertain event. On the happening of the specified uncertain event. Okay. So in that case, what will happen? If that event happens, then that contingent event may become vested, or if that event does not happen, still then also the contingent event may become vested. So on the happening or non-happening of such event, the interest that was contingent may become vested. Okay. Now, yes, vested interest, contingent interest difference is 19 is vested, contingent is 21. Vested does not depend upon fulfillment of any condition. It creates an immediate right, but contingent is dependent upon fulfillment of condition, and it is not fulfilled if the interest is fails. Interest fails, then it is not yes. Then coming to effect of transfer is death. So just because the transferee dies before he obtains possession, that does not make it divested. And contingent interest is if he dies before obtaining possession, then the interest is defeated. Okay. Now present right of enjoyment, yes, there is present immediate right even when the enjoyment is postponed, but in contingent interest there is no present right of enjoyment. It is a mere promise for giving such a right. Illustration, you may see, if I say I am giving this to you after death, then that is vested. But if I say that if only you would marry my daughter, then only I would give this property to you, then that is a contingent interest, because that may happen or may not happen also. Okay. Now 22 is transfer to a member of class who attains a particular age. Okay. If I say that I am transferring this property and it will be transferred to whom? A member of a class who will attain a particular age. Okay. If I say that, then in that case, those who attain that particular age will get it, and those who do not attain that particular age will not get it. Now 23, transfer contingent on happening of specified uncertain event. Transfer contingent on happening of specified uncertain event, and here I am not specifying any time. Okay. So here there is a transfer which is contingent on happening of a specified uncertain event, and there no time is specified for such event. Then in that case, if subsequent event fails, before termination of the prior interest, then contingent interest would also fail. Okay. So if the before the termination of the prior interest, if the subsequent event fails, that means it becomes impossible, then contingent interest would also fail. So A is transferring to B for life and then to C. That means C must get it before before B's death. If before B's death C does not get it, then interest will fail. Then interest will fail. That is section 23. Now 24. 24 is transfer to such persons who survives at some period and exact period is not specified. So exact period is not specified and it is said that it will be transferred to such persons. Then in that case, what will happen? Interest passes to those who are alive. Okay. So I'm saying that yes, I'm transferring to certain persons, but those who will be surviving at certain period, then only it will go to them. Then if they are alive, then it will go to them. If they are dead, it will not go to them. So A transfers to B for life, and then to C to D, C and D. But what happens that before B, in fact, sorry, C dies before B's death. Then only D is surviving, so only D will get it. Only D will get it because he is only alive, and if C is dead, then he will not get it. Okay, this is what 24 is. Now coming to 25. 25 is conditional transfer. What happens that interest is created and it depends upon a condition which is either impossible, forbidden by law, impossible, forbidden by law, or against public policy, or fraudulent, or it defeats the provision of law. Then in that case, what would happen? It would not be, it cannot be put because these are conditions which cannot be put. You can't put condition which is impossible. If I say that I will transfer this property only if you run 100 miles an hour, it is an impossible condition. If I say I will transfer this property if you kill someone, that is a forbidden by law. Or if I transfer this property if you indulge in gambling or indulge in prostitution, that is certain conditions. These conditions you cannot put. Section 25. Now section 26 says that if there is a condition precedent, then if it is substantially complied with, still then it would be deemed to be fulfilled. So if it is a condition precedent, then if it is substantially complied with, still then it would be deemed to be fulfilled. But if it is a condition subsequent, then in that case it has to be strictly fulfilled, otherwise it will not be deemed to be fulfilled. Because why? Because law will always want that the vesting should be done, and it would always want always want that divesting should not be promoted. Okay, so that's why condition precedent will be deemed to be fulfilled if it is substantially complied, but condition subsequent will be deemed to be fulfilled if it is strictly complied, not when it is just substantially complied. Next, it says conditional transfer to one person and you are coupling with a transfer to another person on failure of prior disposition, then in that case doctrine of acceleration would apply. Even if it does not fail in that particular manner, still then it would be valid. Still then it would be valid. So what does it say? That yes, I am transferring this property to B, and then as an ulterior disposition it would be transferred to a certain person. Now even though it does not fail in that particular manner, still then it would be deemed as if it had failed. Okay, now section 28, that there is an ulterior disposition which is conditional on the happening or non-happening of an uncertain event. Okay, now there is an ulterior transfer which is conditional on happening or non-happening of a uncertain event. Then in that case, if it happens, then in that case what will happen? If it happens, then what will happen? If it happens, then what will happen? So what does it say? That yes, on the happening or non-happening of this specified uncertain event, this will happen. So if he gets the job, suppose if he put a condition, he transfers it to B and says that then it will go to C, and it says that if he gets the job within 3 years, then it will go to C, or it says if he does not get a job in 3 years, then property will go to C. So in that case, the alternate disposition will happen either on the happening or non-happening of the specified uncertain event. Okay, next, prior disposition not affected by validity of ulterior disposition. What does it mean? What does it mean? That even if the ulterior disposition is invalid, prior disposition remains valid. Even if ulterior disposition is invalid, prior disposition remains valid. So A, who has transferred it to B for life and then to C. If B do not desire a husband, then property will go to C. If there is a condition like that, then ulterior disposition in favor of C is invalid, but prior disposition of in favor of B remains valid. Prior disposition in favor of B remains valid. Okay. Section 30 says this much. Just a minute, guys. I'm coming from washroom. Okay. So yes. So prior disposition is not affected by the validity of ulterior disposition. That is section 30. Section 31 says if there is a condition which I say that yes, the transfer will cease on the happening or non-happening of uncertain event, that is also I can put, this is basically a subsequent condition. Condition subsequent. This is a condition subsequent. Okay. So if I put a condition like that, that can be put or not. Yes, that can be put. Okay. But such condition must not be invalid. So whatever could not be the condition precedent, those cannot be put as well. We studied that on what conditions cannot be put as subsequent condition precedent, like that of impossible conditions forbidden by law, etc. So while putting condition subsequents also, you have to keep it in mind that you can't put conditions which are not valid, Now, transfer conditional on performance of act when time is specified and time is not specified. So if there is a transfer, we are saying it is conditional on the performance of an act, and here time is not specified. Then if the condition is broken when the act is rendered impossible, condition will be deemed to be broken when the act is rendered impossible. And if there is a transfer conditional on the performance of the act but time is specified, then if the performance is prevented by fraud by person who would be benefited, then further time shall be allowed. And if no time is specified, then, and if there is fraud, then condition will be deemed to be fulfilled. Okay. Now this is transfer 33, 34. Now coming to 36, 37, that is apportionment. That says that one person transfers to another person, but he keeps it for 15 days, and after 15 days he transfers it to B. So on 15th day it is transferred. So how it will be? So there is a property which is sold from A to B on the 15th of the day. Then how it will be the rent accruing thereof? How it will be apportioned between the transfer and the transferor and the transferee? It says that if rent is for 300, suppose, then if it is sold on 15th August, then day to day for 15 days he will get 150 rupees, and for other 15 days he will get 150 rupees. So simple math, he will get as per the days that he had held it. Okay. Now coming to the apportionment by estate. What is apportionment by estate? It says, suppose there is a person A who is transferring into B and C. Okay, and to B he is transferring 1/3, and to C he is transferring 2/3. Okay, B and C he is transferring. Then in that case, if the rent was 1200, then it was being given to A previously. Now it will be given to B and C. How it will be given to B and C? It will be given in proportion to their shares. That means 400, that is 1/3 of 1200, will be given to B, and 800, that is 2/3 of 1200, will be given to C. Okay, that is apportionment by estate. Of course, if there is something which cannot be severed, or it increases the burden substantially, then it can be delivered as per the instruction of any of, as per the combined instruction of such persons. It can be delivered to anyone. Suppose the rent was 1200 rupees and a goat. So of course you can't deliver half of the goat. So whole of the goat you will deliver it to anyone, or as per the instruction of the both the parties, you can deliver it to anyone. Coming to doctrine of election, which is very very important. It says that suppose there is a person X who is transferring a property, who professes to transfer a property belonging to Y. So Y is in fact the owner, but X is the transferor here. He is willing to transfer the property of Y to Z. Okay. So transferor is X, he is transferring to Z, but he is not transferring his property, but he is transferring Y's property. Okay. And by that transfer, he is putting a benefit on the owner. He is giving a benefit on the owner, and he is transferring that property. Then in that case, Z has the option of either electing to keep the property or rejecting it. So if he elects to go ahead, not go ahead with the transfer, then in that case 10 lakh that was given will be reverting back to X, but he can keep the property. But if he says no, I want to keep that 10 lakh, then in that case the property will also go to Y. Okay, here Z, if he does not get it, then he becomes the disappointed transferee, and he has certain right. He has certain right to claim compensation. He has certain right to claim compensation as well. Okay. So now if the owner rejects the transfer, then the transferee becomes disappointed transferee, and if the transfer is gratuitous, that is without consideration, then transferee is entitled to the value of the property if transferee dies before election. But if the transfer is non-gratuitous, that is with consideration, then transferee is entitled to value of property whether transferor is alive or dead. Still, then he will be liable to get the value of the property. Okay. And some important points that you have to consider is, yes, election may be either express or implied. Now owner has to elect it within 1 year. If he fails to elect within 1 year, then transferor may give some time, and if within that time also he does not elect, then it will be deemed acceptance. Okay. Now if the owner is disabled to elect, then election is postponed until cessation of disability, or it is made by the legal guardian. Okay. So if the owner is disabled to elect, election is postponed until cessation of disability, or it is made by the legal guardian. Okay. Next, you will have to remember that, yes, the whether the transferor believes or not does not believe that the property belongs to him, it is immaterial. Still, then it will be applicable. Okay. And second, if a person is taking the benefit directly, but not taking the benefit directly but taking it indirectly, then in that case he did not elect. Suppose what happens in the same example, what happens, X is actually giving the benefit to son of Y, and not to Y himself, but he is giving benefit to son of Y, and he says, I am transferring your property to Z. In that case, whether Y needs to elect? No, Y does not have to elect. Why? Because this is a method of indirect giving of property, so he need not elect. Okay. Next, if he is given in one capacity, the benefit is given in one capacity, but the property is sought to be transferred from another capacity, then in one capacity he may reject, and in other capacity he may elect to keep it. Okay. So that is also there. So of course directly it has to be given, in the same capacity it has to be given, as a part of the same transaction it has to be given. Okay. But as a part of same transaction, if it is specified that it is only relating to this particular benefit and not the other benefit, that means X is transferring 10 lakh plus giving a gift of house. It says for the 10 lakh I am transferring the this property to Z, but about the gift of other property he does not say anything. Then in that case, Y has the option of electing to, he has to elect between 10 lakh and house, but the gift with respect to that house he can keep it, he need not elect in respect to that. Okay. And if owner accepts the benefits, then it will be deemed that he has confirmed the transfer, and the presumption will be done that he has elected. But yes, of course he has to be aware of his duty to elect, or he must have waived inquiry under such circumstances. Next is, if there is a presumption, there can be a presumption that owner has accepted the benefits when he has enjoyed the benefits for 2 years, or does any act which renders impossible to place the person in the same condition. So if Y takes 10 lakh from X for 2 years, but he does not elect, then it will be deemed that he has accepted the 10 lakh and has chosen to elect in favor of giving the property. But yes, one more thing, if there is a coal mine given to Y and Y exhausts that coal mine, that means now it will be impossible to render him possible to restore it to the original position. Then in that case also it will be deemed that you have chosen to keep the coal mine and relinquish the property which was sought to be transferred from you. Okay. Now coming to section 38. Section 38 is that if there is a person who is authorized only under certain circumstances to transfer, that is like a Hindu undivided family's karta can transfer when it is for the necessity of the family. Guardian of a minor can transfer when it is for the necessity of the minor. So if there is a person who is authorized only under certain circumstances to transfer, and he transfers alleging the existence of certain circumstances, then in that case he will be barred from denying the existence of such circumstances later. If a suit is brought by the said person that no, this transfer is not valid because the transferor was incapable or no, he was not authorized, he cannot deny that he was not authorized because he did so. He alleged himself that there was an existence of circumstances. That's why it will be deemed that it is a valid transfer. Okay. Now, 39, it says that when there is a transfer by a person, when a third person has a right to maintenance. Transfer by a person when a third person has a right to maintenance. In that case, what can happen if a suppose A is the husband, B is the wife, A has a property. Now B is getting a maintenance from that property. Now if the husband sells that property to C and transferee knows about this right to maintenance, then in that case it can be enforced against if it is gratuitous also it can be enforced against C. Next, this has to be there is a road, and what happens that A is the owner of this entire property. Entire property A is the owner. One part of the said property he is selling it to B. Okay, and other part he is returning it and constructing a house thereon. Here A is putting a condition on B that you can't construct anything on the path. This part you make anything. Why? For the beneficial interest or enjoyment of the house that is constructed by A, he bars B from putting any condition. If he does that, then in that case, suppose B transfers it to C and C transfer is to D, then in that case, if subsequent transferees have notice of this, and they or it is a gratuitous transfer, then in that case what can happen is that this obligation can be enforced, and those later transferees will also be enjoying the property subject to this particular condition. Okay, that is what section 40 actually says. Now 41, transfer by ostensible owner. It says that ostensible owner is a owner who is not an owner per se, but he looks like an owner. Suppose I am driving my father's car. Well, most people might think that it is my car, whereas the car actually belongs to my father. Okay, so here what will happen, that if there is a transfer by the ostensible owner, then and if he is an ostensible owner and with the consent either express or implied of the real owner, he is the ostensible owner, and then what he does is he transfers a property, then in that case it will not be voidable on the ground that transferor was not authorized. That means the real owner cannot now dispute the fact that no, he was not authorized, it is my property, it cannot go. You allowed it to happen, you allowed the ostensible owner to preach as an ostensible owner, and that's the reason he could sell it. So right now you can't dispute it. Okay, but if there is a transferee who acted in good faith and ascertained that transferor was authorized to transfer, then in that case that will not be affected. He will not be affected thereby. Okay. Next, 42. Transfer by person having authority to revoke former transfer. What happens, that transferor is making a transfer and then says that I have the authority to revoke the former transfer. But say next what he does, to someone else, then it will be deemed that he has revoked the former transfer. Why? Because he has the authority, he had retained the authority to revoke the transfer. So when he makes a further transfer, it is deemed that the former transfer is revoked. Now 43, transfer, this is feeding the grant by estoppel. This is transfer by unauthorized person who subsequently acquires interest therein. Okay, so that means imagine there is a property belonging to my father or my grandfather, and I think that I will get the property, and that's why I transfer it to you. And later, what happens when I actually get that property? I say that while transferring it, I had no right, so that transfer should be invalid. No, you had you had promised that you will transfer. Now that this property came to you, you will be bound to transfer it. So person who is fraudulently or erroneously representing that he is authorized to transfer, for consideration he is transferring it, then he is stopped from denying the transfer. Okay, if he acquires any authority or subsequently. Okay, suppose A had X and Y property, but Z property he was expecting to get. Okay, but he sold all these three properties to C. Okay, in 2000 he sold this property, but actually he got the ownership of Z in 2005. Actually he got the ownership of Z in 2005. Then what can happen that in 2005 also C can ask that you give it to me. Why? Because you had transferred it when you did not have authority. Now that you have authority, then in that case it will be you'll have to feed the grant by estoppel. You'll be required to feed the grant by estoppel. Now 44, transfer by one co-owner. What does it say? That yes, if there is two persons who are owners of a particular property, now one co-owner transfers his part to another person. Okay, suppose A and B are jointly having this entire property. Now what happens? B is selling his 1/4 share. He had 1/4 share, so he is selling his entire share to C. Now C will have all the rights of possession, of demanding a partition, all the rights that B had, he will have. Joint possession, partition, all these rights he will have. But of course, he cannot demand, or he cannot enjoy joint possession or demand partition when, if the property is a dwelling house of the undivided family, then in that case he cannot demand a joint possession or partition. Other than that, he can always enjoy a joint possession and partition. Okay, 45, joint transfer for consideration. What happens that now an immovable property is transferred for consideration to two or more transferee, immovable property is transferred for consideration. Then how to decide their interest in the property? It says if the transferees have paid out of a common fund, then whatever interest they were entitled to in that fund, according to that they will get an immovable they will get the immovable property there, I mean in proportion to that share. And if they have paid out of a separate fund, then whatever amount they have contributed in proportion to such share, they will get the property. They will get the property. Okay, and if there is no evidence as to interest in fund, then it shall be presumed that all have equal interest in the property. Okay, next, transfer for consideration by person having different interest. So previously 46 45 we studied that if it is transferred to more two transferees, then how it will be going. Now if the two transferers are there and they have sold it, then in that case how will they get the consideration? So if there are two transferers who have sold it to C, A and B transferred to C, now if they normally if they have equal interest, then they will get the consideration equally. But if they have unequal interest, then they are entitled to the consideration in proportion to their value of the interest on the property. So whatever is the value of interest in the property, they will get their interest in the said property like that. Okay, so suppose they had equal interest A and B, so half we were getting. Suppose they had 3/4 and 1/4 interest, then instead of half they will get 3/4 and 1/4 of the entire consideration amount of 1 crore, that is he will get 75 lakh A and B will get 25 lakh. Okay. Next, transfer by co-owner of share in common property. So what does it say? There are A, B, and C who are having this entire property. A is having half, B is having 1/4, and C is having 1/4. Now they decide they want to transfer half of this property. They want to decide they want to transfer half of this property. Okay. So out of this property they want to transfer half. Okay. Now how it should go? Whether A's entire property will go? No. A's 50% will go, B's 50% will go, C's 50% will go. A's 50% of 1 by 2 is 1 by 4th, B's 50% of 1 by 4th is 1 by 8, and C's 1 by 4th 50% is 1 by 8. So in proportion to this, it will go. So all of them will have to sell 50% of their land. Oh, so in proportion, they will have to share the burden. That's what it says. 48 is priority of rights created by transfer. Now this has to be read along with 78, 79. It says that whatever right is created first will prevail over the right created subsequently. Okay, so that means if I do what, I make a transfer of a property first to B and then I sell it to C, of course the first right will prevail. First right will always prevail. Okay, so because why? Because the first in point of better in point of priority of rights will be given. Next, 49 is transfer is right under policy. Transfer is right under policy says that if there is a policy that has been obtained by the transferor, in insurance policy is obtained by the transferor. Now, when the transferor gets that insurance money, he may ask the transferor to apply such insurance money in reinstating such property. He may say that you apply this insurance money to reinstate the property. Now, section 50, rent bona fide paid to holder under defective title. It says suppose A is the owner and he has given a lease to B for rupees 50 every month. Now what happens? A, who is the owner, has sold this property to C, but A does not know about this transfer, and B does not know about this transfer, and he simply goes and rent is paid to A. Then in that case, B is not liable to pay to C anymore. B is not liable to pay to C anymore. Okay. Next, 51. Improvements made by bona fide holder under defect. So what does it say? If transferee, believing in good faith that he is absolutely entitled to property. Okay, so transferee, in believing in good faith that he is absolutely entitled to property, is subsequently evicted from a person having better title, then he can ask him to pay value of improvement. So suppose A did not have any title but he sold it to B. Now B made certain improvements. Okay, now whether C will be whether now C, who is having a better title, that means he was in fact the owner. He comes and he wants to oust C from the possession. Now whether C can get any compensation? Yes, he can ask him to pay the value of the improvement. Which be improvement, whatever he has made, he can ask to pay him, or at least he can ask that you please uh, sell the interest in the property to transferee at the market value. So you might say that at least you sell your interest to me so that I may keep it. Either you pay my improvements for high value or sell your interest in the property to the transferee at the then market value. That is at the time of the eviction, the market value that will be paid. Okay. Now, if the transferee has suppose sown plants, crops, then if he is evicted, then in that case he is entitled to the said crops and free ingress and egress to get the same, that is also included within that right. Now coming to section 52, doctrine of lis pendens. Okay. Now during the pendency of any suit in court of competent jurisdiction, if the suit is not collusive, then, if there is a right to immovable property is directly and specifically in question, then property cannot be transferred. Property cannot be transferred except with the authority of the court. The property cannot be transferred. Okay. Now, pendency is from the date of commencement till the end of the suit. commence when the presentation of plaint is done or institution of suit is done, and it is continue till this suit is finally disposed of by decree or order. Till then, this doctrine of litispendence is applied. That means party cannot transfer it during the pendency of the suit without authority of the court. Okay. Next, fraudulent transfer. Fraudulent transfer, of course, you have to understand that yes, there is a transfer of property, and this is made with an intention to defeat or delay the creditors of the transferor. Then it is voidable at the option of the creditor or the transferee. Okay, so if it is for consideration, it is voidable at the option of transferor, sorry, creditor, and if it is without consideration, then in that case it is voidable at the option of transferee. It will not affect the rights of the transferee in good faith and for consideration, and it will not affect the insolvency laws as well. Okay, but if a creditor is instituting a suit, then in that case it shall be deemed to be instituted on behalf of all the creditors. Okay, so similarly, this is just protecting the creditors for from any fraud that can be committed by into their transfer. Then that will be fraudulent transfer, and it will be voidable at the option of the creditor or transferee. Okay. Now 53A, part performance. Part performance says, suppose there is a person who contracts to transfer for consideration any immovable property by writing signed by him or on his behalf or transferee in his part performance, and has taken the possession of the property. Transferee, what has he done? Transferee has taken the possession of the property, or he is continuing to be in possession and does some act in furtherance of contract, and has performed or is willing to perform his part of the contract. Then in that case, transfer remains valid, and transferor shall not enforce any right against the transferee. Okay, so B B to B, he was planning to sell for 1 crore, but before sorry, B had paid 60 lakh, and he has the possession now. Well, in fact, before the sale could be entirely complete, what happened? A was trying to sell it to C because the market value increased, or C offered more. He said that I will just sell it to C. No, he can't do that because B had already performed his part. It is for consideration, and he is in possession, and he has performed his part or is willing to perform his part. Then in that case, that's why the transfer will be valid. Uh, uh, Valid, and transferor cannot shall not enforce any right against the transferee. Transferor shall not enforce any right against the transferee. Now, this is how our general transfers rule. Now coming to sale of immovable property. Now specifically we'll discuss them: sale, mortgage, etc. So sale, what is it? Transfer of ownership in exchange of price paid or promised. Okay, now it is different from contract for sale. Why? Contract for sale is you are making an agreement to sell. Okay, now you may sell it or you may not sell it, but when it is sale or contract of sale, that means sale is already made. And sale, how it will be made? If it is greater than 100 rupees, then always through registered instrument, and if it is less than 100 rupees, then registered instrument or delivery of possession. Okay, we are talking about delivery, sorry, sale of immovable property. We are not talking of sale of movable, because sale of movable will be dealt under the SOGA. Sale of movable will be dealt under SOGA. Okay, next, what are the, yes, difference between agreement of sale, contract for sale, and contract of sale? Contract for sale, it is a future transfer, but here it says immediately. Here it is a conditional transfer, it is absolute. Here it is executory contract, it is executed contract. Here, title of goods with the seller, there is no transfer, as there is no transfer, but title of goods transfers to the buyer as there is transfer. राइट टू सेल इन कॉन्ट्रैक्ट फॉर सेल किसके पास है? सेलर के पास. कॉन्ट्रैक्ट ऑफ सेल में राइट टू सेल इज विद द बायर. Now right of unpaid seller, that is he has right to sue for damages, and contract of sale, the right of unpaid seller is that he has a right to sue for the price. Now, liabilities of seller are this. Liability of seller before seller: duty to disclose material defects, to produce all documents relating to property, to answer all relevant questions, to execute proper conveyance, to take care of property, to give possession of property, to pay all public charges. After sale, he has, when whole purchase money has been paid, he is bound to deliver all document and title deed to the buyer. Similarly, right of seller, what is it? To receive rent and profit arising out of property till ownership passes to buyer. And after sale, if the ownership of property has passed to buyer before payment of whole amount, then seller has a right to charge upon property of the unpaid amount from the date on which possession has been delivered. So he has a charge. Liabilities of buyer, similarly, before sale, the buyer's liability is that he is to disclose the material defect which increases the value, or to pay the purchase money to the seller. After money, if any loss is accruing, then he has to bear the loss, or due to injury, destruction, or decrease in value, and to pay all public charges and rent payable in respect of the property. Okay. Similarly, rights of the buyer are what? Rights of the buyer are to receive benefits of improvements, increase in value, or rents, profits arising out of property till ownership passes to buyer. And after sale, ownership property has passed to buyer before payment of the whole amount, then seller has a right to a right of amount from the date on which possession has been delivered. Coming to section 56, that is marshalling by subsequent purchaser. What happens here? That A has mortgaged three properties to B. X, Y, and Z, three properties he has mortgaged to B. But later on, mortgage କଲା ପରେ ତାକୁ ସେଲ୍ ବି କରିପାରିବ ନା ନାହିଁ? ହଁ, ସେଲ୍ ତ କରିପାରିବ। ତେଣୁ ତାପରେ କ'ଣ କଲା? ସେ ଖାଲି Z ପ୍ରପର୍ଟିଟା ସେଲ୍ କଲା C କୁ। ସୋ ତିନିଟାକ ପ୍ରପର୍ଟି B କୁ mortgage ପକେଇଥିଲା, ତାପରେ Z ପ୍ରପର୍ଟିଟାକୁ mortgage କଲା C କୁ। ଓକେ, ନାଉ suppose X, say XYZ mortgage ପକେଇଲା ବେଳକୁ ସେ ଆଣିଥିଲା କେତେ ଟଙ୍କା? ସେ ଆଣିଥିଲା suppose 40 lakhs he had gotten. Okay, now for 50 lakh he has sold which properties? Z. तो से जेटी sorry से बिकिची C को, Z property बिकिची C को. now C पाखरे गोटे marshalling rights अछि जे से कहि परिबो जो property टा मते बिका हेनी, in respect of those properties you please satisfy your mortgage debt. आगो X और Y बिकी कि तम mortgage debt satisfy करिया को ट्राई करो, जदि तापर भी तम न बिकी पारलो, न satisfy करि पारलो, ताले you may touch Z. So not that you can't touch Z at all, but just that you cannot touch Z first. You'll have to touch X and Y in order to satiate your claim against X and Y first. Now 57 रे कहला जे आपण फ्री फ्रॉम एनकम्बरेंस कोर्ट डिक्लेयर कर परिबो जेतले डिपॉजिट और पेमेंट इन कोर्ट हुए, सेतले जेतले जति के सम चार्ज अछि जदि सेटा डिपॉजिट करा जाय, देन इन दैट केस बायर को नोटिस दिया जाय आ तापरे कोर्ट सेठी कहि परंती जे yes now you are free from encumbrance declare करी हबो. Coming to mortgage and charge कोन कहला लार्जेस्ट चैप्टर एटा टीपीआर रो कोन कहला जे ट्रांसफर ऑफ इंटरेस्ट इन स्पेसिफिक इमूवेबल प्रॉपर्टी, गोटे आपण इंटरेस्ट जदि स्पेसिफिक इमूवेबल ट्रांसफर करचंती कोन पई as a security for payment of loan, then in that case that's a mortgage. आउ जहा को ट्रांसफर करचंती ताको mortgagee, जे ट्रांसफर करची ताको ट्रांसफरर, जो इंस्ट्रूमेंट रे ताको ट्रांसफर करा होची ताको कहआ जाय mortgage deed. आउ जो अमाउंट रे टा आपण दउचंती आपण पाउचंती in order to transfer, that is called mortgage money. आउ mortgage टा केमती हुए? mortgage टा 100 रो ऊपर सेले registered instrument रे हबो, signed by mortgager and two witnesses. किंतु mortgage by title deed टा रे registration दरकार नहीं, सेटा normally कोथरे भी हे परिबो. सेमती less than 100 हेले registered instrument दरकार, आउ sign of the mortgager and two witness दरकार. किंतु सिंपल mortgager जदि less than 100 अछि ताले खाली delivery of possession रे भी काम चली पारिबो. So 58B कोन सेठी mortgager निजु को bind करूची to pay the mortgage money, personally he binds himself and agrees to pay the mortgagee, and if he fails to pay then mortgagee shall have a right to sell the mortgage property, and सेठी delivery दिया होची कि delivery दिया होनी. Conditional sale कोन आपण ostensibly sell करचनी mortgage property on condition that if default of payment is done on a certain date the sale shall become absolute, on payment the sale shall become void. एठी आपण delivery दोचंती, so it is conditional sale. Now usufructory mortgagee to retain possession until payment of the mortgage money and to receive the rents and profits accruing from the property in lieu of the interest, and this is with delivery. English mortgage, एठी भी mortgager कौन करूची bind to निजकु to repay the mortgage money on a certain date and transfers the mortgage money mortgage property absolutely to the mortgagee provided he will retransfer to the mortgager. एठी retransfer करियो बोली कोची, and that is also with delivery. आउ by title deed creditor को जदी documents of the title to immovable property दिया होची with intent to create security, that is without delivery of the property, that's a mortgage by title deeds. Now anomalous mortgage is जदी कोडा भी simple नो, conditional नो, usufructory नो, English नो किमा deposit by title नो, माने mixture है पर anything, then in that case depending on that you may hold it like a mortgage. Mortgager liabilities and rights कोन, rights होची तारो mortgager रो कोन जिसे सबले redeem कर परिबो, it's an absolute right. Mortgagee को require कर परिबो जैसे third party को transfer कर पारू instead of retransfer to mortgager. To inspect and production of documents, to redeem separately or simultaneously, right of usufructory mortgager to recover possession, usufructory mortgage possession भी मागी परिबो, accession to mortgage property or mortgage property ପାଇଁ जदी थिला बेले किसी property extra तको मिलिला से जो alluvial soil या जदी river पाकर थिला तो extra किसी मिलेला से access गुडा भी तको मिलिबो. से mortgage property जदी improvements किछि करछि ताले he is also entitled to that. दरकार पड़ले mortgage deed को renewal भी करि परिबो आ mortgager रो power भी अच्छी जैसे लीज रे भी देई परिबो. लायबिलिटी कोन, implied contracts by the mortgager, waste by mortgager in possession, ए दिटा होची लायबिलिटी. जदी तार पोजीशन थलाले वेस्ट हे गला देन तारो पाकरे अच्छी लायबिलिटी. then the rights and liabilities of mortgagee, rights कोन mortgagee रो foreclosure sale करि परिबो, recovery of mortgage money पई भी सेल करि परिबो, आउ power of sale केतले without court केतले valid सेटा में पडिबा, receiver appoint करि परिबो, accession जदी हेतो mortgage property रो then he'll be entitled, right to renewal of mortgage property जदी चाहिबो renew कर परिबो, right to spend money to preserve property from destruction सेटा भी कर परिबो, right to proceeds of revenues a sale or compensation or acquisition भी कर परिबो. Liabilities रे कहला liabilities of mortgage in possession of mortgage property कौन कौन प्रॉपर्टी को मैनेज करिवा, रेंट प्रॉफिट कलेक्ट करिवा, गवर्नमेंट रेवेन्यू पे करिवा, नेसेसरी रिपेयर्स करिवा, नो डिस्ट्रक्शंस इफ इंसल्ट अप्लाई मनी रिसीव्ड, कीप क्लियर फुल अकाउंट्स ए सब करिवा को पड़िबो. ओके, मॉर्गेजर सबले जानि थांतु राइट ऑफ रिडेम्पशन अछि. थरे जतेले मनीटा ड्यू हे गला देन इन दैट केस सेठी मॉर्गेजर कोन करि परिबो ना रिक्वायर करि परिबो मॉर्गेजी कि तू मॉर्गेज डीडटा सब डॉक्यूमेंट दे, पोजीशन दे, मते रीट्रांसफर कर आ एक्नॉलेजमेंट दे. partial redemption allowed ki partial redemption allowed nahi, kintu jodi mortgagee or all mortgagee has acquired whole or part of the share of the mortgager sethi alga katha, nole partial mortgage partial redemption is not allowed. Mortgagee ra semti right achi kono, right of foreclosure or sale, right of foreclosure or sale ra right achi karo mortgagee ro kono achi jodi se dele mortgage money ta due he gala ta pore jodi chahibo जे परंत रिडेम्पशन न होई से परंत से कहि परिबो से ऑब्टेन करि परिबो गोटे डिक्री फ्रॉम कोर्ट जोथरे की बार होबो मॉर्गेजर फ्रॉम रिडीमिंग द प्रॉपर्टी. फोरक्लोज माने आपण बार करचंती काकू फोरक्लोजर आपण बार करचंती मॉर्गेजर फ्रॉम रिडीमिंग द प्रॉपर्टी, दैट इज फोरक्लोजर. इफ दिस इज डन देन आपण आउ कोन करि परिबेनी, आपण आउ रिडीम करि परिबेनी. नाउ implied contract of sale, implied contract of sale कौन कहला implied contract of sale? Yes. Now power to transfer interest which he has, एठी कौन कहला जे गोटे मॉर्गेजर और implied contract अछि जे से जदी चाहिबो किछि करि परिबो इंटरेस्ट जोडा अछि ता पकरे ताकु से इंटरेस्ट को ट्रांसफर कर परिबो. टाइटल को भी डिफाइन करिवार ता पकरे राइट अछि. तापरे आउ कोन अछि mortgager to pay all public charges when property in possession of the mortgager. mortgage property जदी लीज ताले तार रेंट रिपे करिवो आउ प्रायर mortgage को पे करिवो. if there is subsequent mortgage then prior mortgage को भी पे कर परिवो बोली अछि implied contract by mortgager हम पढिया. power of sale केतले valid, mortgagee जदी चाहिबो without intervention in the court केतले करि परिवो सेल. जदी इंग्लिश mortgage हेतिबो आउ mortgagee mortgager is not Hindu, Buddhist or Muslim ताले कर परिवे. आउ कोन कहला जदी power of sale without court's intervention is expressly conferred on the conferred on in a mortgage by title deed and mortgagee is government, then in that case सेठी करी हबो. अब थर्ड रे जदी सेतरे भी विदाउट इंटरवेंशन केतल कर परिबो if the mortgage property is situated in town of Bombay, Madras or Calcutta, सेतरे भी आपण without intervention of the court करी परिबे. ओके, किंतु सेल करिया को हेले नोटिस दवा पड़िबो मॉर्गेजर को, आउ जदी 3 मंथ्स पर्यंत वेट करिया पड़िबो जे से नोटिस रो किछि रिप्लाई दोनी डिफॉल्ट करूची, ताहले ही जाई कि आपण एडा कर परिबे, नहले करि परिबे नाही. 69 एति कहला. 69 ए कहला कोन अपॉइंटमेंट ऑफ रिसीवर. अपॉइंटमेंट ऑफ रिसीवर कोन कहूची? अपॉइंटमेंट ऑफ रिसीवर जे आपण केमति कर परिबे? मॉर्गेजी कर परिबो इन राइटिंग साइन कर परिबो. कहा को रख परिबो? जहार ना मॉर्गेज डीड रे अछि आ जे विलिंग अछि टू एक्ट. इफ नॉट विलिंग ताहेले अपॉइंट भी कर परिबे हाकू, आउ नहले अप्लाई भी कर परिबे कोर्ट को अपॉइंट करिया पे. तार कोन पावर? से इनकम को रिकवर करिवो, रेम्युनरेशन रखि परिबो, आउ ताकू इंश्योर्ड करिक रखि परिबो, आउ तापरे हाउ टू अप्लाई मनी रिसीव्ड, सेठी जहा पैसा से पाउची सेठी से रेंट टैक्सेस को पे करिवो, एनुअल सम्स को पे करिवो, निजर कमिशन किबा प्रीमियम ऑन फायर लाइफ इंश्योरेंस सब रखिवो, इंटरेस्ट पे पे करिवो, तापरे डिस्चार्ज ऑफ प्रिंसिपल पे पे करिवो. ओके, कोर्ट को जल्दी चाहिए एप्लीकेशन करि परिबे फॉर हिज ओपिनियन एंड एडवाइस विदाउट इंस्टीट्यूशन ऑफ सूट फॉर मैनेजमेंट और एडमिनिस्ट्रेशन ऑफ प्रॉपर्टी आपण करि पारि मॉर्गेज प्रॉपर्टी आपण एटा करि पारिबे. नाउ राइट टू प्रोसीड्स ऑफ सेल और कंपेंसेशन और एक्विजिशन. एठी कोन कहला जदी मॉर्गेज प्रॉपर्टी सोल्ड ड्यू टू फेलियर टू पे रेवेन्यू और पब्लिक चार्ज, मु कहिदे जेले पब्लिक रेवेन्यू न दिया जाय ताले प्रॉपर्टी को बिका जाई पारे. सो सेठी जदी आपण एटा न देले, then in that case if it is not due to default of the mortgagee, then mortgagee कौन कर परिबो? क्लेम कर परिबो पेमेंट फ्रॉम दी मॉर्गेज मनी. पेमेंट मॉर्गेज मनी रो पेमेंट पई, मॉर्गेज मनी रो पेमेंट पई से गोटे तार राइट टू क्लेम अछि. कोठू? सरप्लस ऑफ द सेल प्रोसीड्स रु एंड आफ्टर पेमेंट ऑफ द एरियर चार्ज. आउ केतेले कर परिबो? जेले मॉर्गेज मनी, मॉर्गेज प्रॉपर्टी इज एक्वायर्ड अंडर लैंड ऑफ एक्विजिशन एक्ट, ताले मॉर्गेज रे गुड राइट अछि टू क्लेम पेमेंट ऑफ मॉर्गेज मनी आउट ऑफ अमाउंट ड्यू टू मॉर्गेजर और कंपेंसेशन. असले समथि प्रायोरिटी एठी दीटा जनसन 78 79 रे कोन कहला जे प्रायर मॉर्गेज ता सब्सिक्वेंट मॉर्गेज को हेई परिबो पोस्टपोन केते बेले जदी फ्रॉड करथियो. फ्रॉड करी कि गोटे प्रायर मॉर्गेज कर दबो सो दैट सब्सिक्वेंट मॉर्गेज जेंति हैरान हो, ताले कोन हबो ना सब्सिक्वेंट मॉर्गेज एक्चुअली ताकू आगु पळेसबो एंड प्रायर मॉर्गेज जे फ्रॉड पाइथिला से पछुकू पळेबो बोली कहिला. किंतु 79 रे कहला जदी मॉर्गेज रे गोटे अनसर्टेन अमाउंट सिक्योर करूचंती आउ हेतरे मैक्सिमम टा एक्सप्रेस करचंती, देन जदी भी सपोज भवंतु जेंति बैंक 1 टू गोटे आनिला से गोटे ताकू लेटर ऑफ क्रेडिट भले आनिला 40 लाख टका रो, जे 40 लाख बटा परन जेतल इच्छा नहीं परिबी. 1 जनवरी नेला 30 लाख, 1 फरवरी नेला 10 लाख, इन बिटवीन से बैंक टू रु 15 जनवरी नेची 15 लाख. तो आगो 30 लाख तापर जाय कि आसीबो 15 लाख, तापर जाय कि आसीबो कोडा 10 लाख. काहे कि ना आपण कोडा करछंती जेतु आपण आपनकर आगो नेची कोडा आगो नेची बैंक 1 टा, तापर नेची बैंक 2 टा, तापर नेची बैंक 3 टा. सॉरी आगो नेची बैंक 1 टू 1 तापर 3 तापर 2, किंतु एक्चुअली पेमेंट हेला को हबो कोडा 1 तापर 2 तापर 3. काहे कि ना फर्स्ट फरवरी भी से नेची 10 लाख. ओके, सो सेठी पेमेंट हेला को आपण हेटा प्रीपोन हे जिवो. एठी 2 3 भूल लिख दीची. एठी फर्स्ट फरवरी नै थिले भी से आगो पे करिवो. एटा 3 हबोनी, एटा 2 हबो. आगो पे करिवो 2 को, काहे कि ना एक्चुअली मैक्सिमम टा एटी स्पेसिफाई हेतिला. तणु 1 2 3 15 जनवरी टा इनफैक्ट आगुरु हेतिले भी सेटा पर को पळेबो. प्रायर टा हेतिले भी सेटा पर को पळेबो. काहे कि ना आपण जेतु मैक्सिमम टा स्पेसिफाई कर देइथिले. तंदी मार्शलिंग बाय सब्सिक्वेंट मॉर्गेजी कोन कहला एठी जदी ए XYZ को गोटे XYZ प्रॉपर्टी को B को दोची मॉर्गेज रे, और तापरे खाली Z प्रॉपर्टी टा को C को दोची सब्सिक्वेंट मॉर्गेज रे, ताले सेठी C कहि परिबो जे आगो तम मॉर्गेज डेटा सैटिस्फाई करो प्रॉपर्टीज व्हिच आर नॉट मॉर्गेज टू मी. तामने X और Y रु ट्राई करो सैटिस्फाई करिया पई. तापर जदी न होबो ताले तमे Z को टच करिवो, जहा तादरु डेफिसिट रहउची तमे नै परिवो. किंतु आगो ट्राई करो X और Y को ठु नवा पई. काहे कि ना ए प्रॉपर्टी मते एक्सक्लूसिव मॉर्गेज हिची, तुमको XYZ 3 टा कहि पारे, बट Z टा खाली मोर गोटे प्रॉपर्टी अछि. तो सेठी अरेंज करिया पई दी थिंग्स इन अ पर्टिकुलर मैनर मार्शलिंग टा आपण कहि परिबे बोली कहला ओके कंट्रीब्यूशन समथि कोन कंट्रीब्यूशन कहला जदी भाबंतु ए बी सी कोन करचंती ना एक्स वाई जेड प्रॉपर्टी तीनटा अछंती तांकर एक्स वाई जेड शेयर तांकर अछि ए रो शेयर होची 1/2 आउ y रो शेयर होची 1/4 आउ z रो शेयर होची 1/4 तीन जण मिसी तांकर प्रॉपर्टी ता देइचंती d को आउ 10,000 टका टोटल b पे कला ए नै गला केते 5,000 b नै गला 2.5 के z नै गला 2.5 के जदी एबे ए एंटायर अमाउंट रिपे कर देला ताहले से बी आउ सी टू से 2.5 के तांको प्रोपोर्शन शेयर रू उठै परियो बोले रूल 1 टा कहला सेंति रूल 2 कहला जदी दीटा प्रॉपर्टी अलगा अलगा अछि आउ गोटे प्रॉपर्टी मॉर्गेज हेची गोटे लोन द्वारा आउ गोटे प्रॉपर्टी ता सिक्योर हेची दीटा लोन द्वारा आउ तादिरु माने भाबंतु एक अंकला ना एक्स प्रॉपर्टी टा को मॉर्गेज पके की C2 ने आसिला 400 टंका ओके तापरे एक अंकला ना पुनी एक्स वाई दीटा को मॉर्गेज पके की D2 ने आसिला केते टंका 800 टंका नाउ एक्स रा प्रॉपर्टी रा वैल्यू से 1000 टंका आ वाई रा प्रॉपर्टी रा वैल्यू भी से 1000 टंका ताले नॉर्मली कोन हबो ना आगो फर्स्ट प्रॉपर्टी रा पे हबो फर्स्ट मॉर्गेज टा पे हबो माने 1000 टंका रु आगो 400 टंका चली जिवो एबे रहला तार वैल्यू केते 600 टंका आउ सेकंड प्रॉपर्टी रा वैल्यू केते 1000 टंका सो 600 is to 1000 that is 3:5 3:5 रे पे हबो एबे जदी 800 टंका टोटल ताको पायर अछि डी को तार से 300:500 रुपीस बढ़िया पाई जिवे बोली कहला आउ रूल 3 होची मार्शलिंग विल प्रिवेल ओवर कंट्रीब्यूशन दैट मींस कंट्रीब्यूशन को सबले मार्शलिंग प्रिवेंट को कोन ये करिवो प्रिवेल करिवो नाउ डिपॉजिट इन कोर्ट 83-84 रे देला जे आपण जदी चाहिबे आफ्टर मॉर्गेज मनी हैज बिकम ड्यू आपण और सूट फॉर रिडेम्पशन फाइल को लागुरु जदी चाहिबे आपण कोर्ट रे डिपॉजिट भी करि परिबे पैसा 83-84 नॉट दैट इंपोर्टेंट आपण देख देबे तापर असला रिडेम्पशन की रिडीम करि परिबो मॉर्गेजर रिडीम करि परिबो जे की पर्सन इंटरेस्टेड से भी रिडीम करि परिबो चार्ज अछि से करि परिबो श्योरिटी करि परिबो क्रेडिटर करि परिबो सब्रोगेशन होची जदी किए भी मॉर्गेज जदी भी किए रिडीम कला ताले से कोन करिवो तार पोजीशन को सब्रोगेट हे जिवो ओके तार पोजीशन को सब्रोगेट हे जिवो बोली कहला दैट इज राइट ऑफ सब्रोगेशन सपोज ए बी सी तीन जण अछंती गोटे बी खाली जदी ताकू मॉर्गेज ताकू रिडीम करची ताले से सेठी ता पोजीशन को सब्रोगेट हे जिवो ता पोजीशन को सब्स्टिट्यूट हे जिवो बोली कहची प्रोहिबिशन ऑफ टैकिंग कोन टैकिंग होची जे आपण भाबंतु ए कोन कथना ना बी को देथिला फर्स्ट मॉर्गेज 2000 टका थिला सी को देथिला सेही प्रॉपर्टी को सेकंड रे देला 5000 टका आनला डी को पुनी थर्ड रे सेही प्रॉपर्टी को देकी 10000 टका आनला एबे डी जदी बी रो पैसा टा को पे कर दोउची 2000 टका पे कर दोउची से कोन ता जगह को सब्स्टिट्यूट हे जिवो की नो से सब्स्टिट्यूट हबो ओनली विथ रिस्पेक्ट टू दैट 2000 पई से बी जगह को जिवो बट नॉट की तारो जो अमाउंट अछि 10 के ताकू भी नै की सेट से ऐड कर दबो आगो कोन हबो डी को पे हबो से 2000 तापरे सी को पेड हबो तारो 5000 तापरे डी को पेड हबो तारो 10000 सेटा कहला प्रोहिबिशन ऑफ टैकिंग सेंती मीन मॉर्गेज रो राइट कोन जदी मझरे के ओडे मॉर्गेज अछि जेंती सी जदी सी सपोज एबे सी रो कोन राइट अछि जेंती सबले मॉर्गेजर रो राइट थाए कोन रिडीम करिया पे मॉर्गेजी रो राइट थाए कोन फोरक्लोज करिया पे और सेल करिया पे सेंती जदी गोटे मीन मॉर्गेज अछि तारो कोन राइट अछि जे से सबु बेले फोरक्लोज करि परिबो कागु फोरक्लोज करियो सी कागु सबले फोरक्लोज करि परिबो एटी कोन रिडीम अप एंड फोरक्लोज डाउन रिडीम अप एंड फोरक्लोज डाउन माने अपवर्ड्स जे थिबो आपण ताकू रिडीम करि परिबे डाउनवर्ड्स जे थिबो ताकू आपण फोरक्लोज करि परिबे ओके नाउ रिडेम्पशन बाय को मॉर्गेजर सेठी कहला जदी को मॉर्गेजर रिडीम करूची ताले एक्सपेंस जहां भी आपण पे हिची से सब से रिकवर करि परिबो को मॉर्गेजर रु बोली कहला ओके एनुमलेस मॉर्गेज रो राइट्स एंड लायबिलिटीज कोन हबो जोटा की मॉर्गेज बाय टाइटल डीड्स रो जहा राइट से हबो नले लोकल यूसेज द्वारा डिटरमिन हबो 99 टा रिपील हे जाईची तापर असले चार्ज टा इज लाइक ए मॉर्गेज बट सेठी कोन एठी इमूवेबल प्रॉपर्टी को ऑन इमूवेबल प्रॉपर्टी एक्ट ऑफ पार्टीज किबा ऑपरेशन ऑफ लॉ रे गोटे सिक्योरिटी क्रिएट करा होची फॉर पेमेंट ऑफ मनी सेठी कोन होतला गोटे आपण गोटे सिक्योरिटी करथले फॉर ए लोन एठी गोटे पेमेंट ऑफ मनी रो सिक्योरिटी करचंदी एंड दैट इज थ्रू एक्ट ऑफ पार्टीज और ऑपरेशन ऑफ लॉ ओके सेठी कहला जदी सब्सिक्वेंट इनकम ट्रांसफर थिवो तांकर मर्जर हे जीवनी बोली कहला सपोज ए कोन करची बी को आगो प्रायर मॉर्गेज देची नाउ व्हाट हैपेंड सी को सब्सिक्वेंट मॉर्गेज देला सपोज ताले सपोज एबे कोन आपण जदी एना प्रायर मॉर्गेज जदी रिडीम कर देला प्रॉपर्टी को से कोन ओनर हे जीवो की आपे आपे नो सेठी आपण मर्जर हबनी दी जण को इंटरेस्ट अलग अलग रहिबो बोली कहला चार्ज रे ओके नोटिस कोन कहला जे एजेंट को नोटिस सफिशिएंट होची एजेंट टू प्रिंसिपल नोटिस टू प्रिंसिपल आउ लीगल गार्डियन को जदी नोटिस देला कि मार गार्डियन एड लिटन को नोटिस देला दैट इज आल्सो सफिशिएंट इन केस ऑफ ए इनकॉम्पिटेंट पर्सन 104 रे रूल के तयारी कर परिबे हाई कोर्ट तयारी कर परिबे बोली कहला तापरे लीज ऑफ इमोबल प्रॉपर्टी कोन कहला जे एथरे आपण कोन करचंती गोटे राइट ऑफ एन्जॉयमेंट आपण दोचंती फॉर ए पर्टिकुलर पीरियड जदी आपण दोचंती दैट इज ए लीज आपण मैन्युफैक्चरिंग और एग्रीकल्चर पर्पस पई ईयर टू ईयर लीज करिवे अदर पर्पस पई मंथ टू मंथ लीज करिवे बोली कहला कंसीडरेशन कोन होई पारे सर्विस प्राइस मनी और शेयर कॉर्पोरेशन जा भी चाहे पारे ओके ईयर टू ईयर लीज टर्मिनेट करिया पई 6 मंथ्स दरकार नोटिस आउ मंथ टू मंथ नोटिस करिया पई 15 मंथ्स दरकार बोली कोजी आइदर लेसर और लेसी के भी नोटिस दे परिवे हाउ लीज केमती हुए मैन्युफैक्चरिंग और एग्रीकल्चर लीज 1 ईयर अपवर्ड से रजिस्टर्ड इंस्ट्रूमेंट अदर्स जदी हबो 1 ईयर लेस ताले रजिस्टर्ड इंस्ट्रूमेंट रे भी परिबो डिलीवरी ऑफ पोजीशन रे भी हेई परिबो नाउ राइट ऑफ लेसर कोन कहला राइट ऑफ लेसर ट्रांसफर कोन कहला एठी लेसर ट्रांसफर कोन कहला सपोज एठी लेसर कोन कहला ना आउ जण को ट्रांसफर कर देला तले से बे ट्रांसफर हे गला जहा जहा राइट्स लेसर थिला से सब राइट्स पळे आसीबो ट्रांसफरी रो काहे कि ना से एबे से लेसर जगह को पळे आसीला जेतले ताटू से किनिला ओके सेमती टाइम कंप्यूट कला को आपण पार्ट डे गुडा को एक्सक्लूड करिवे आउ जो दिन लिस्ट तयारी करिछि से दिनटा भी एक्सक्लूड करिवे आउ आपण ड्यूरेशन टा केतिक हबो ड्यूरेशन टा आपण एनिवर्सरी हबो माने पूरा जो दिन 1 जनवरी जदी गोटे हैला लीज ताले केबे सेटा सरीबो 1 जनवरी 2021 रे सरीबो जदी 2020 रे हितला ओके डिटरमिनेशन ऑफ लीज केमथि हुए एई सब वे रे ही लीज टा डिटरमिन हेई पारे एफ्लक्स ऑफ टाइम हैपनिंग ऑफ स्पेसिफाइड इवेंट जदी लेसर टर्मिनेट करिवो ऑन द स्पेसिफाइड ऑफ स्पेसिफाइड इवेंट और लेसर और लेसी जदी मर्ज हेजिवो इंटरेस्ट जदी इंप्लाइड सरेंडर हबो एक्सप्रेस सरेंडर हबो किबा फोरफीचर हबो किबा नोटिस टू क्विट हबो ताले हे पारिबो राइट्स एंड लायबिलिटीज कोन जे आपण लेसी रो राइट्स होची एन्जॉय एसेसन to treat lease void if property is destroyed due to fire flood violence to deduct expense for repairs made by him after determination of lease remove all the things he attached to earth may transfer absolutely whole or any part of his interest in property by way of mortgage or sublease liabilities and kono rent pay karibo disclose karibo lesser ko any fact which increases the value of the property to keep the property in good condition now allow lesser his or his agent to inspect at reasonable time make good for default caused by lessee in 3 months after notice inform lesser of any proceeding to recover property or encroachment not to erect any structure not to use property on determination give possession to lesser then the lesser liability kono recover kariya rent inspect kariya property at reasonable time recover possession after the completion of lease liability of lesser and the kono to deliver possession to disclose any material defect in the property एवडा होची सबु राइट्स एंड लायबिलिटीज ऑफ द लेसर सेंती केते बेले आपण फोरफीचर वेवर केमती हे परिबे फोरफीचर करिकी आउ नोटिस टू क्विट ताकू भी केमती कर परिबे सेटा देला बा तापरे रिलीफ अगेंस्ट फोरफीचर कोन देला 114 और 114 रे जदी आपण चाहेबे 15 डेज नोटिस देकी आपण मागी परिबे एट द हियरिंग आपण रेंट उडा को पेमेंट करी परिबे बोली कहला अदर पर्पस रे आपण जदी नोटिस देकी ब्रीच करी रिमेडी मागी परिबे एडा आपण टिके देखि देबे सेंती डॉक्ट्रिन ऑफ होल्डिंग ओवर देला 116 रे जदी लीज रो टर्मिनेट परे भी लेसी कोन करूची पे करूची आ लेसर एक्सेप्ट कर दोची ताले धरा जीवो जे सेटा रिन्यू हे गला ईयर टू ईयर हेताउ कि मंथ टू मंथ हेताउ हेडा रिन्यू हे गला बोली धरला 117 रे कहला एग्रीकल्चरल पर्पस पई हेडा एग्जेम्पशन स्टेट गवर्नमेंट सेटी नोटिफिकेशन रे कहि परिबे बोली कहला इट इज एक्सेप्टेड तापर सेमती आसीबा एक्सचेंज 118 टू 121 रे कोन कहला जे एठी कोन होची सेल रे कोन होतला गोटे प्राइस पेड पई किमा प्रॉमिस पई आपण आ गोटे गुड्स टे दोतले एठी कोन होची गुड्स को गोटे इमोल प्रॉपर्टी दोतले एठी कोन करचंदी जे वन थिंग फॉर अनदर थिंग और आपण सेठी जदी मनी फॉर मनी सो मनी फॉर मनी हे पारे किमा थिंग फॉर थिंग हे पारे सो नाइदर थिंग्स बीइंग मनी और बोथ द थिंग्स बीइंग मनी दीटा केस रे हबो ओनरशिप ओके तापरे हसला कोन जे एठी डिफेक्टिव टाइटल हेले डिप्राइव हबो आउ तापरे 120 रे कहला जे सेठी जहा जहा राइट्स एंड लायबिलिटीज कोन हबो से सब जहा सेलर और बायर रो जहा जहा राइट थिला से सब रहइबो जोटा से दोउची तार रेस्पेक्ट रे से सेलर रो राइट्स पाइबो सेलर रो लायबिलिटीज पाइबो आ जोड़ा से नोउची तार रेस्पेक्ट रे से बायर रो राइट्स और बायर रो लायबिलिटीज पाइबो आ मनी एक्सचेंज कला बेले आपण जेन्युइननेस ऑफ मनी वारंट करंती बोली कहला ओके नेक्स्ट नेक्स्ट असला कोन यस हाउस जदी आपण एरा एग्जांपल हला केमते आपण करिवे तापर गिफ्ट कोन कहूची आपण कर परिवे मूवेबल प्रॉपर्टी कर परिवे इमूवेबल प्रॉपर्टी कर परिवे दैट हैप्स टू बी विदाउट कंसीडरेशन डोनर द्वारा हवा दरकार डोनी हेटी एक्सेप्ट करिया दरकार आउ एक्सेप्टेंस केतेले अलाउड ड्यूरिंग द लाइफ टाइम ऑफ द ओनर डोनर और डोनर इज कैपेबल ऑफ मेकिंग इट आउ गिफ्ट कोन कहला जदी आपण आफ्टर द डेथ ऑफ डोनर करा होची ताले सेटा वॉइड बोली कहला केमिति गिफ्ट करा हबो इमूवेबल प्रॉपर्टी रो गिफ्टटा रजिस्टर्ड इंस्ट्रूमेंट रे हबो signed and by two attesting witness मूवेबल प्रॉपर्टी रो गिफ्टटा रजिस्टर्ड इंस्ट्रूमेंट signed and two attesting witness हे परिबो किंबा डिलीवरी ऑफ प्रॉपर्टी रे भी हे परिबो किछि असुविधा नाही तापर आसिला एक्जिस्टिंग प्रॉपर्टी रो जदी सहित फ्यूचर प्रॉपर्टी मिसै की गिफ्ट करचंदी देन सेठी आपण कोन हबो आपण किछि वैलिड किछि ये अछि ताले आपण करि परिबे जे एक्जिस्टिंग प्रॉपर्टी रो वैलिड हबो फ्यूचर प्रॉपर्टी रो void हे जिवो तापर आसला गिफ्ट टू सेवरल पर्सन वन ऑफ देम डू नॉट एक्सेप्ट से केस रे आपण कोन करिवे जदी जणे एक्सेप्ट कर किछि जणे एक्सेप्ट करचंती आ बाकी जण रिजेक्ट करचंती देन इन दैट केस जो माने एक्सेप्ट करचंती तांको रेस्पेक्ट रे वैलिड हबो जो रेस्पेक्ट रे रिजेक्ट होची तांको रेस्पेक्ट रे void हबो बोली कहला देन दसला रिवोक सस्पेंड कोन डोनर डोनी डिसाइड करचन जदी जे ये केस रे विल ऑफ द डोनर डोनी रे डिसाइड होची जे गिफ्टटा सेटा गिफ्टटा रिवोक हबो ना नहीं ताले गिफ्टटा वैलिड हबो आ परे रिवोक भी करि परिबे किंतु जदी विल ऑफ डोनर ओनली रे सेटा डिसाइड हबो देन गिफ्ट विल बी void चाउ से आपण रिवोक तो करि पारे छाडंतु गिफ्ट ही void हिजो बोली कहला ओके ओनरस गिफ्टटा कोन जदी आपण किछि गिफ्ट रे किछि बर्डन पकोचंदी दैट इज ओनरस गिफ्ट सिंगल ट्रांसफर रे जदी बर्डन पकाउची ताले आइदर आपण होल्ड डीटा को एक्सेप्ट करिवे न रिजेक्ट करिवे किंतु जदी इंडिपेंडेंट डीटा ट्रांसफर करी की करूचंती ताहेले आपण बेनिफिशियल पार्टटा रखी की बर्डन सम पार्टटा आपण रिजेक्ट कर दे परिवे इट्स अप टू यू यूनिवर्सल डोनी कोन जे कि डोनर जतेले तार सब प्रॉपर्टी डोनी को दिए ताको आ जाय यूनिवर्सल डोनी ताको सब लायबिलिटी भी मिल जाए टू द एक्सटेंट ऑफ द प्रॉपर्टी किंतु चैप्टर 7 टा नॉट एप्लीकेबल टू मुस्लिम लॉ और डेथ पेड गिफ्ट दैट इज डोनेशियो मोटिस कॉजा को एप्लीकेबल नहे तापर असला एक्शनेबल क्लेम कोन कहला जे claim for unsecured debt or any beneficial interest in movable property not in the possession of the claimant that is an actionable claim सेठी केमती आपण ट्रांसफर कर परिबे with or without consideration आपण ट्रांसफर कर परिबे राइटिंग रे ट्रांसफर कर परिबे साइन करी की ट्रांसफरर किंतु केतेबेले एक्सेप्शन होची आपनकर मराइन और फायर इंश्योरेंस सेटा अलगा कथा 135 रे कहला असाइनमेंट करि हबो की यस असाइनमेंट ऑफ इंश्योरेंस करि हबो नाउ 131 रे कहला जदी आपण नोटिस टा केमती देबे आपण राइटिंग रे देबे एक्शनेबल क्लेम जदी ट्रांसफर हला तारे नोटिस टा आपण डेटर को देबे आइदर ट्रांसफरर दबो किबा एजेंट दबो जदी समय रिफ्यूज करचंदी ताले ट्रांसफर ही दबो ओके तापर आसिला वन हां तापर आसिला 132 दैट लायबिलिटी ऑफ ट्रांसफरी ऑफ अकाउंट एठी कोन कहला जहा भी ट्रांसफर रो लायबिलिटी से सबु पुनी आसी जिवो बोली कहला नाउ आपनकर वारंटी कोन कहूची जे जते बेले आपण गोटे एक्शनल क्लेम टा ट्रांसफर करचंती आपण वारंटी दोचंती ट्रांसफरर काकू डेटर को दैट ही इज solvent up to the consideration amount जते amount of consideration सेति amount पर्यंत से solvent बोली गोटे guarantee दोचंदी आ mortgage debt जदी किछि अछि ताको सिक्योर करिया पे जदी actionable claim ट्रांसफर कराउची ताले ट्रांसफर जदी चाहिबो ताले रिकवर करि परिबो सेडा केमिति हबो रिकवर ना आइदर कॉस्ट पई आगो पे हबो तापरे अमाउंट सिक्योर्ड पई तापरे जाय कि रेसिड्यू गुडा ट्रांसफरर को मिलिबो ओके तापरे आसिला रेस्ट्रिक्शन रेस्ट्रिक्शन कोन जा जो माने लीगल प्रैक्टिशनर जज किबा ऑफिसर ऑफ कोर्ट छंती से माने एक्शनेबल क्लेम रे ये रे पार्टिसिपेट कर परिबे नहीं कि केनि परिबे नहीं 137 रे कहला एक्शनेबल क्लेम कहा को अप्लाई करे नहीं ए स्टॉक शेयर आपण नेगोशिएबल इंस्ट्रूमेंट डिबेंचर मर्केंटाइल स्टॉक ए सब को अप्लाई करे नहीं एक्शनेबल क्लेम रे कोन इंक्लूड हुए क्लेम फॉर एरियर ऑफ रेंट क्लेम फॉर मनी claim for money due to due insurance policy for return of the earned money, right to get back the purchase money when the sale is set aside, right of a partner to sue for an account of the dissolved partnership firm, right to claim benefit under a contract for the purchase of goods, right to get the proceeds of a business, lottery tickets, benefit of contract giving the option to purchase a land, right to benefit of contract, right to credit in a provident fund, dividend on shares, insurance money, rights under the license, right to the proceeds of business, annuities payable under deed or walk off ए सब होची आपनकर एक्शन क्लेम रे इंक्लूडेड किंतु राइट टू गेट डैमेज अंडर द लॉ ऑफ टॉर्ट्स क्लेम फॉर मीन प्रॉफिट्स तापरे कॉपीराइट पैटेंट ट्रेडमार्क डिक्री ऑफ फॉर जजमेंट और डेट राइट टू सू क्लेम इन द शेयर ऑफ प्रॉफिट कूपन वाउचर ए सब आपनकर एक्शनेबल क्लेम नुह बोली कहला ओके तापरे इंपोर्टेंट डॉक्ट्रिन्स टिके देखि दियंतु doctrine of cypress देछि 26 रे doctrine of perpetuity 14 रे doctrine of failure of prior interest 16 रे doctrine of accumulation 17 doctrine of acceleration 27 rule of double possibility is 13 doctrine of election 35 doctrine of apportionment 36 and 37 doctrine of holding out 41 doctrine of contribution 82 तापरे marshalling 56 81 bidding the grant by estoppel 43 then lease pendency is 52 part performance is 53a consolidation is 61 subrogation is 92 waiver of forfeiture is 112 and doctrine of holding over is 116 okay so this in a nutshell completes our transfer of property act and prelims perspective रे आपन को कोन पढिया पड़िबो आपन एतिकी ही देखिबे sections रू बेसिक क्वेश्चंस आसीबो मैक्सिमम आपण सेक्शंस को मन रखिया पड़िबो बहुत उडे ता छडा कांसेप्ट जदी आपण टिके जानि थिबे then you will be able to attend maximum questions 8 to 10 questions आसीबो so again becomes very important because not that big a subject unlike CPC CRPC IPC ए सब तो बहुत छोटा ही सब्जेक्ट तनो आपण if you pay little attention you can get good marks. If you have any doubt, you ask. Otherwise, we'll end the session. If any doubt, please let me know. Otherwise, we'll meet tomorrow and discuss probably IPC. आमर IPC और CPC दीटा को रहला. आउ सब जगह सरी जाइची. IPC दीटा class, CPC दीटा class रे सरी जिवो. Then we will again proceed from our usual जो हमें leave करथिले classes as in CPC I think we were discussing CPC जो हमें छाडिथिले सेठो में पुणी discuss करिया start करिया okay thank you then we'll meet tomorrow and discuss IPC और CPC जहाँ भी schedule रे अछि सेटा करिया okay thank you
sir
yes
sir, there was a question, meaning of intervivals. So there were different options. One was like between living persons, and then another option was living persons, which includes company, association, body of individuals. ଆଉ अन्य ऑप्शन गुड़ाक थिला तो ये दीटा भितर कोन माने इंटरवाइवल्स माने केवल लिविंग पर्सन ही हो
includes body of corporations एडा भी हबो
Okay, vivals ର meaning ଟା living नुहो माने it also includes company association body
yes
of individuals.
basically living person includes your corporate मु लिखि दिली सेत पई देखन दो मु सेतरे लिखि दिली the living person includes any body of persons, company or corporations as well.
Okay, sir. So it is IPC ro hi definition bhaliya ହେଇଯିବ ସେଇଠୁ
Yes, yes,
living
yes,
person ର
yes.
Okay, sir. Yeah. Okay. Thank you, sir.
Okay, thank you. Thank you all. We'll meet tomorrow.